Citation number 799, compulsory treatment after imprisonment for sexual offender. Date, 2020. Issue, to Article 91-1, Paragraph 1, Subparagraph 1 of the Criminal Code, the danger of committing the offense again, and the Paragraph 2, Subparagraph 1 of the same article prescribing that the risk of recidivism is significantly reduced. Violate the void for vagueness doctrine and the proportionality principle. Does Article 22-1, Paragraph 3 of the Sexual Assault Crime Prevention Act, the risk of recidivism is significantly reduced, violate the proportionality principle and the liberty and the security of a person doctrine under Article 8 of the Constitution? Do the Code of the Criminal Procedure and the Sexual Assault Crime Prevention Act, which do not provide the opportunity for the person liable to the penalty to appear in court when applying for a declaration or cessation of compulsory treatment, violate the principle of due process of law under the Constitution? Is the process of examination and evaluation under Article 91-1, Paragraph 2, first sentence of the Criminal Code insufficient in protecting the procedural rights of the person liable to penalty, thereby violating the right to judicial remedy under the Constitution? Does the Article 22-1, Paragraph 1 of the Sexual Assault Crime Prevention Act, which mandates compulsory treatment for perpetrators who have previously committed sexual offenses prior to the amendment of the Article 91-1 of the Criminal Code on June 30, 2006, violated the principle of retroactivity and the principle of reliance protection. Holding, Article 91-1, Paragraph 1 and 2, first sentence of the Criminal Code do not violate the void for vagueness doctrine. Article 91-1, Paragraph 1 does not contravene the principle of proportionality and does not violate the protection of liberty and the security of a person of the Constitution. The period of compulsory treatment to significantly decrease the risk of committing the crime again under Article 91-1, Paragraph 2, first sentence of the Criminal Code, and Article 22-1, Paragraph 3 of the Sexual Assault Crime Prevention Act does not violate the principle of proportionality. There may be, however, several concerns of violating the Constitution regarding long-term compulsory treatment in certain circumstances. The relevant authorities should adjust and improve in accordance with the spirit of this interpretation. Article 22-1, Paragraph 1 of the Sexual Assault Crime Prevention Act does not violate the principle of non-retroactivity and the protection of reliance protection. Both the Code of the Criminal Procedure and the Sexual Assault Crime Prevention Act do not provide for the chance for the people liable to the penalty to appear in court in person or by mandating a defense attorney when applying for declaration or termination of compulsory treatment. Nor provide a rule that there should be a mandated defender on their behalf when the person liable to penalty is so affected by mental disorder or impairments that they are not able to appear in court in person. These omissions within the scope mentioned above do not comply with the principle of due process of law as enshrined in the Constitution. The relevant authorities should amend these provisions within 2 years from the date of this interpretation's announcement until the necessary amendments are completed, the courts should handle the declaration and determination procedures of compulsory treatment in accordance with the spirit of this interpretation. Article 481, paragraph 1, second sentence of the Code of Criminal Procedure does not violate the right to judicial remedy of the Constitution. The current compulsory treatment system has, over the years, exhibited tendencies that resemble punishment deviating from the constitutional requirement to clearly distinguish it from the execution of criminal penalties. That is, compulsory treatment should be clearly distinguished from the execution of criminal penalties. The relevant authorities should adjust and improve no later than 3 years after this interpretation is made public to ensure that the results of compulsory treatment comply with the constitutional requirement of clear differentiation. So there is a principle of clear differentiation of compulsory treatment and criminal penalty. Okay, bye-bye.